For Crema Media's Polity, I'm Sane Dhlamini. Researcher and analyst Professor Raymond Suttner joins me for Suttner's View, a weekly commentary on South Africa's political scene. Welcome, Professor.
Thank you.
What do you think of Speaker Baleka as well as the ANC chair's suggestion that some of the judges are biased against government as well as the ANC?
Yeah, you know, this is something that happens sort of seasonally. They leave the judges, and then every now and again they decide to hit the judges. And I think it's a way of deflecting attention from what they've been doing. I'm not suggesting that the courts are above reproach, that there's nothing that we can criticize about the judiciary. But when he first became Secretary General, Mantashe attacked the judiciary at a certain point, and I actually attacked Mantashe in Business Day about 2008 or something like that. But Ramatlodi, Zuma and others have also attacked them recently. Zuma said at the conference, the very funny democracy where, you know, the elected people make a decision and then the opposition who lose it go to court and have it reversed. Now, there's something a bit dishonest in that sort of argument, because what they are trying to do is to say who are the judiciary who are not elected to set aside the decision of Parliament that is elected, and the President who's elected by Parliament, and indirectly the Cabinet are appointed by an elected person. Who are they to an elite institution who is unelected? Who are they to set things aside? So what they are really doing, in my view, is not dealing with why it is that the judiciary does its job despite being unelected, but it is really an attack on the Constitution. Because when people go to court, if they succeed in court, what it means is that the President, a Cabinet Minister or some official or Parliament itself, as in Nkandla, have not observed their duties under the Constitution. And if they have not observed their duties under the Constitution, the judiciary is the body that is charged with interpreting the Constitution and deciding whether or not an allegation that the Parliament, whoever it has been, has not abided by its constitutional duties, whether it's valid or not. It's an allegation until the court has come to a finding. In order to come to a finding, a court cannot simply say, this is absurd. What they have got to do is, whatever their personal views may be, they have got to say, in terms of Section 41 or Section 36 of the Constitution, read together with Section 21, the duties of an officer of government who decides on this, that and the other is to do so following the following procedures. He or she must have heard this and must have heard that, got representation from this one. Only then can a decision be valid. And the thing is then that the courts are very well aware of the fact that Parliament has got a legitimacy that they do not have politically by virtue of being elected by voting of the electorate. Consequently, the courts are very careful, and it's illustrated in the case over the secret ballot. They made a decision saying that the Speaker had been wrong to say she is not allowed to decide on a secret ballot. They said there is nothing in law or in the Constitution that says she can't have a secret ballot. But they said, we are not entitled to make that decision as a court. because that would be interfering with the powers of the legislature. And therefore, we refer the matter back to the Parliament to make a decision on whether or not to have a secret ballot. So they are very conscious of being an unelected body, and that there are boundaries for every arm of government for what they must do. And they only enter it when it has not been done in a proper manner.
So why do you think they are not challenging court cases on the basis of this claim of bias?
You see, it's quite difficult. And in this, you may think that Balega Mbete is making a valid point. It's quite difficult to show that a decision was made because a judge is anti-ANC. Now, even if a judge is anti-ANC, when the judge has to make a decision, they cannot make that decision on the basis of being anti-ANC. They have to make a legal decision. They have to say that in terms of this law and that law, no matter what the motive of the person may be, this does not conform to the law. For example, even under the apartheid government, if our Parliament did not follow the procedures to make a law, in 1952, for example, they wanted to remove the coloured voters from the voters' roll, and according to the Constitution, you had to have both Houses of Parliament sitting together in order to make that decision, and they didn't do that. And by passing that, what they called legislation, without following the procedures, it was not a law. So the court decided that by not conforming to what was required to make a valid law, it was not a law. Equally, if you can show that the minister has not, or the president has not applied his mind to a matter, if the minister has to make a decision, and you can prove that the minister did not have before him all the relevant data. For example, if you can prove he never had the CV of someone where CV is relevant to the decision, you may have it set aside. So unless you have, regarding a judge making a decision, unless you can show that there is some flaw in the reasoning of the judge in terms of at the level of magistrate or Supreme Court, that they refuse to hear a certain witness. Because usually on appeal, courts don't interfere with factual decisions. They only have appeals mainly on decisions of law. But if factually they shut a person down who has material evidence, they can set that, they can say, that would be an example of bias, not necessarily ANC bias, but bias which could be set aside. Or where you can show that the judge, by virtue of being a card-carrying member of Boeremag or something like this, and having presenting an affidavit to the court saying that he had said in a bar or somewhere this, that and the other, and you can prove it. That would be an example where you can show A, the person had these political views, B, outside of the courtroom, he had said he's going to send these people to jail for 20 years or he's going to set aside all these decisions. So it's quite hard to set it aside, but it's not for the Constitutional Court to remedy this just sitting there and saying, judges, be fair to the ANC. What the ANC has to do, if they think they're being treated in a biased way, they have got routes to follow. They go to court, they bring a court action to set aside a decision, and they must produce evidence which shows that this decision could not have been arrived at apart from bias towards the ANC, and they haven't done that. So I think this is part of the rhetoric of people trying to outdo one another when some, you know, if you attack the courts, you're really saying we really didn't do such bad things over in Nkandla, the SASA grant scandal. It's the courts who make it up as if we did things bad. So they're trying to divert attention.
Thank you, Professor.
Good.
That was Professor Raymond Suttner speaking to Creamer Media's Polity about renewed attack on judiciary.